Hello, my name is Paula Mahan. I'm an attorney licensed here in California, and I practice in a very limited area of family law. That limited area is the law that supports a highly specialized field of medicine. The medical field is called ART, A-R-T. Today, ART is the new frontier in infertility treatment, and the law that I practice strives to do two things. One, to bring these innovative technologies into the mainstream of our society so they become widely available, and two, to give legal recognition to the children born through the use of these technologies. Let me pause here to give you some context, who I am, and how I got involved in the law of ART. I graduated in 1978 from Hastings College of the Law. Hastings is part of the University of California system and is located in the heart of downtown San Francisco. I took and passed the bar that same year. My first job out of law school was as a deputy district attorney for the County of Los Angeles. I was a criminal prosecutor in a very hectic job. 16-hour days, back-to-back trials, an unsustainable career for someone who also wanted a family. So, after a period of time, I left there and went into private practice with my husband. Part of our new practice involved the full gamut of family law, including the good old divorce, custody, support wars. Through this phase of the business, I met a small group of people at bar association functions, professional society luncheons, and so forth, who were talking and thinking out of the box about infertility and how to fix it. Some were doctors, some were clinic staff, and some were fledgling agencies doing egg and sperm donation and surrogacy and trying to link into the clinic businesses. The more I learned, the more interested I became. I realized that what they were thinking, talking, and doing, even though it was servicing such a small group of people at that time, was ultimately going to change how our culture and our society came to view the sacrosanct parent-child relationship. In the mid-1980s, this whole movement was dealt a harsh blow by a disastrous surrogacy case arising out of New Jersey, referred to as the Baby M case. I will give you a great deal more information about this train wreck in video 2. I will also tell you about the huge strides we have made in surrogacy in California as a result of seminal cases that came down in the 1990s. But at that time, Baby M was truly a downer. Nevertheless, surrogacy advocates continued to push forward, seemingly undaunted, and by the late 1980s, I too was fully committed and involved in ART law in California. Today, in addition to surrogacy, the field of ART encompasses egg donation, sperm donation, and the new battleground in the war on infertility, embryo donation. But back then, few people knew what these things were, and those who had heard of them found them threatening and upsetting. Change of any kind is not easy. We are trying to change hundreds of years of thinking about how one becomes a parent. It is proving to be a long uphill battle. Traditionally, our society has only known two types of parents, those who have kids the good old-fashioned way and those who adopt. Adoption has never been the path first chosen, well, except for Angelina Jolie. Adoption was always a last resort. Those who did it had such an enormous drive to become parents that they were willing to endure the public exposure and the humiliation of their infertility. But the most painful concession was their willingness to give up their own dreams and settle for parenting someone else's child. Part of my personal objective in this war against infertility is to rid society of the taint of infertility. It should not be shameful. It's just a medical condition, like an allergy to peanuts. So, let's go back to the late 1970s. Momentum was slow. Some gains, some big setbacks. Sperm donation was always easily available. California had passed the Family Code 7613, known as the Sperm Donor Statute, and it had been on the books for decades. As long as all the consents were properly signed and all procedures were done in a doctor's office, the process was pretty much bulletproof. Sperm donors never had to worry about being saddled with parental responsibilities for children they fathered. The statute stated very clearly that the recipient automatically became the legal father. It was nice and clean, and a simple signed release terminated all of the sperm donor's legal rights. Egg donation was not on the radar screen yet. Okay, we're talking now about the late 1970s. Not as far as the consuming public was concerned. The medical technology in egg donation was not good enough, and not many doctors were experimenting with it. Surrogacy did grind on, mostly the artificial insemination kind. But in AI, or artificial insemination surrogacy, the surrogate was both the genetic mother and the legal mother by virtue of having given birth. The couple never knew until they had gone all the way through the pregnancy with the surrogate if she would actually give them a baby. There were no laws that gave them any right to require her to do so. Eventually, egg retrieval did become more commonplace, but the process was IVF using the eggs of the infertile intended mother, merged with the sperm of her husband or an anonymous donor, and then transferred back to the intended mother to carry. Success was spotty and very expensive. The technology was learn as you go, and often a couple had to do many IVF cycles before achieving a pregnancy, if ever. The process was tedious and expensive. The eggs of the intended mother were suspect and were most likely the cause of the couple's infertility. If a pregnancy was achieved, there were often early miscarriages, which was a total and separate independent cause of the couple's infertility. From the late 1970s through the end of the 80s, big strides were made in medical technology. Clinics were perfecting the IVF process. They found they had much more success when retrieving eggs from a younger, fertile donor. The fetus was carried either by the intended mother or, with increasing frequency, a surrogate mother. The genetic father was most often the intended mother's husband. California was way out on a limb during this time period, pushing forward with the medical technology without any law in place protecting the couples in these arrangements. Lawyers labored in the dark during this time. We were burdened by the impact of statutes in the family code that were not intended for surrogacy cases. The biggest offender was Family Code 7610. It was a statute that gave voice to the obvious presumption that the woman who gave birth was the child's legal mother, and made it a hurdle we had to overcome in surrogacy cases. But the only law we had available to us were the step-parent adoption laws. Step-parent adoption was a very long process, taking around 6 months to complete, and we still had to rely on the surrogate to consent to the adoption to make it a success. This made the whole arrangement terribly stressful for the couple, and we just had to find a better way. The task of finding a better way fell to the ART lawyers, A-R-T. Much as we love to hate them, lawyers have a role to play. In art, we are the oil that makes the engine run. Doctors can be out there creating babies in all kinds of unconventional ways, but they need lawyers to mainstream these babies back into society. We had to be the interface between these new ways of creating babies and the old ways of thinking about parents and children, thinking that was very resistant to change. So we formed lobbying groups and approached the legislators in Sacramento. In 1992, we got State Senator Diane Watson to sponsor a surrogacy bill that held great promise. It was intended to serve as a platform or a blueprint for the whole process, start to finish. Lawyers had labored away for years in legislative committees, carving it out of whole cloth. It was an innovative, outside-the-box game changer. What eventually happened to it was never anticipated. This, too, will be part of our subsequent videos. The historical perspective of the evolution of ART from the early 70s to the present is riveting. It is full of medical legal drama, giddy excitement, painful setbacks, and a million anecdotal experiences, both good and bad, from all those caught up in the maelstrom of cultural change. This will be the subject of a future video presentation and will take us forward through the last 35 years to the present state of the law. At the same time, I will explore with you how we use this law to obtain the pre-birth order, otherwise called the PBO. The PBO levels the playing field. It brings new biological parents and new ART parents to the same happy starting line and eliminates the heartbreak and shame of infertility. But for now, we're going to jump ahead to the modern-day surrogacy agreement, that long and intimidating but very essential document that opens doorways into the exciting world of art. The contract. Why do we need surrogacy contracts, and why are they so darn long? Actually, we use contracts in all types of art: sperm donation, egg donation, and embryo donation, as well as surrogacy. But for now, we'll focus on the all-important surrogate agreement. We need surrogate contracts for several very important reasons. The first reason is that the contract documents the parties' intentions. The appellate courts who decided the 3 surrogacy cases relied heavily on the surrogate contracts to discern the mindset of the parties when they entered into this agreement. Again, these surrogacy cases were handed down in the 1990s. They needed this information in order to analyze the claims made by both sides much later on in the litigation case. Courts wanted to know who was not telling the truth, who was reneging on the promises made to the other party at the time the contract was signed, who had conveniently changed their minds in order to accrue a greater benefit than originally bargained for. This is the kind of analysis the court will make in any contract dispute. Along these lines, the courts have told the attorneys, through the language of their rulings, that in all future contracts they want these intentions clearly spelled out. More specifically, they want to see that the lawyers had advised their clients about the law of surrogacy, that the clients, also called the parties, understood and accepted that law, understood and accepted the rights and responsibilities of both sides in the contract, and agreed that their contract would be governed by these laws. To that end, they wanted to see clear statements that the parties had submitted to the jurisdiction of the California courts for the resolution of all disputes. In the clear language understood by non-lawyers, this meant that the surrogate would have no parental rights to the child, no right of visitation, no right to yearly pictures, etc., no right to contact of any kind, that the child will never be found to be her child at any time in the course of this arrangement, and that no adoption will be required. What's another reason why we need a contract? Well, it assures the court that the parties had separate attorney representation. The judges also wanted to make sure it was an arm's length transaction, meaning that no one had a bargaining advantage and could pressure the other party into doing something unfair or unwanted. The courts wanted to satisfy themselves that there was no predatory behavior in the mix, and that the contract was freely entered into by consenting adults. For this inquiry, the court will want to be assured by that the parties were separately represented by independent attorneys. Again, we see here that lawyers actually have some usefulness. They are there to provide a protective barrier, a line of defense against future litigation. They will make sure that their clients were not induced to enter this contract by fraud, misrepresentation, or any kind of improper enticement to enter the contract. A third reason we need the contract: it documents the timeline. I'm sure you're asking yourselves, what the heck does that mean? Well, this addresses an unfortunate situation that first became public in mid-2011. The incident has deeply affected the entire ART bar, meaning all of us who practice in reproductive law. One of our own, in cahoots with another lawyer out of state, wandered off the straight and narrow into what has provocatively been called baby selling. Without going into all the gory details, babies who were not products of legitimate surrogate arrangements were transferred into the hands of desperate parents, and the legalities were processed through the courts as though they were surrogate babies. The criminal activity in this arrangement was in part revealed by inconsistencies in the timeline. Babies could not have been created in the manner alleged in the paperwork filed with the court because the timeline just didn't fit. Angry backlash coming from the courts has spawned dark suspicions about all ART lawyers and has created retaliatory and punitive new rules and regulations on where and how the PBO, or pre-birth order, can be obtained. The court judgment, or the PBO, is the heart and soul of the surrogate arrangement. It establishes the petitioners as the legal parents and instructs state agencies like Vital Records, that creates the birth certificate, to recognize the intended parents as the child's legal parents. It also officially terminates any right the surrogate or her husband might have been granted by operation of law. All of this will be explained in detail in later videos when I discuss current California law and how it operates to get the PBO. When we file for the PBO, we now have to lodge the contract with the court so they can make sure that all events follow sequentially and logically from the signing of the contract until the birth of the child. So if the court documents say that the contract was signed in January, med procedures started in March, the surrogate conceived in May, and the baby was born the following February, the contract, which predates all of these events, better be consistent with that timeline. So the contract validates the judgment documents and vice versa. Now you can appreciate the importance of the contract. It has to be prepared by a highly experienced lawyer with expertise in ART law and must contain all the parties' intentions, all details of the arrangement, including financial arrangements, and a full explanation of existing law. It cannot be prepared safely by non-lawyers from a one-size-fits-all blueprint you get off the internet. So, besides all of the legal requirements the contract must have, what else should it have? It should instruct the parties on how to handle anomalies or emergencies that are a usual and customary event in any pregnancy. But because of the parentage issues and financial issues, the parties need guidance on who makes which decisions and who is financially responsible for covering the extra costs that these events will generate. Let's look at some examples. First example, we have a surrogate pregnancy in place, and something goes wrong in the second trimester. The surrogate is suddenly bleeding and cramping, and she's at home alone. It's 1 in the afternoon, and she has to pick up her kids at 3. How should she handle this? Wait until after she gets her kids home to deal with the problem? No. The contract directs her to call the agency immediately and then an ambulance. The agency will alert the surrogate's family to pick up the kids, or the agency will send out one of their own to do the pickup. All this will have been discussed and plotted out in advance. Her obstetrician will be notified so he can visit her in the hospital. If he puts her on disability, the agency will know who to apply to and how to apply for disability benefits if she is eligible. The agency will make sure that she gets the cleaning, shopping, and child care that she needs in order to remain on bed rest. The agency will notify the attorney about this situation and will send along an itemization of expected costs, so domestic helpers, even if they are family or friends, will be paid for their services during the entire disability period. This will be part of intended parents' unexpected expenses that the contract already warned them might occur. Let's look at a second example. Again, a surrogate pregnancy is in place. What if by ultrasound or by amnio, the baby is discovered to have a serious condition that will substantially affect its quality of life? The doctor recommends abortion. Is this the time for the agency or the parties to discover that the intended mother is pro-choice and the surrogate is pro-life? No. Whose decision is it to make? The contract will spell all this out, including the specific medical circumstances that determine who is to make the decision on whether or not to abort. Medical care, recovery time, financial costs and reimbursements, etc., will be anticipated by the contract and approved by the parties well in advance of this contingency, just as it would have been for the example above on disability. Let's look at a third one. Again, this is a surrogate arrangement, but it's at the beginning of the arrangement, in the contract phase. Should the agency allow the intended parents to eliminate some elements of the program in order to save money? What if the client wants to skip psych screening and counseling on the surrogate in order to save money? The answer is no. A good agency is successful because the agent has learned by trial and error over the years what provides the greatest protections for her clients. I learned years ago from an agency I used to accept referrals from the terrible cost of sacrificing quality and control for money. The agency was desperate to find a surrogate for a couple who was just about to sign their retainer and pay their fees. The agency relaxed their screening standards and got a psychologist to clear a surrogate that they knew from past experience was a troublemaker. In late pregnancy, under the stress of carrying multiples, the surrogate's aversion to authority took over, and she began to exhibit defiant behavior, balking against all the advice she was getting from her doctor, her parents, and the couple. She disappeared for long periods of time, told no one where she was, refused to go to her doctor appointments, and told her doctors not to discuss the pregnancy with the intended parents. It was a nightmare, especially for the couple. This surrogate had done the same thing in a prior surrogate arrangement, but in this case, her defiant behavior had escalated to an alarming degree. Personality traits of this kind are easily detectable by a good psychologist and would have totally disqualified her. Luckily, in the end, it all turned out okay. The babies were born healthy and the couple took them home without incident, but the potential for disaster took a terrible toll on the couple. For all of these reasons, the integrity of the program must never be compromised. Here is one more example. Another agency, which is no longer in business, was run by an agent who was simply unqualified for the substantial responsibilities the agency must undertake. The agent is responsible for referring the parties to appropriate experts to obtain proper medical insurance. The surrogate worked outside the home and her employer was self-insured. The agent didn't bother to read the policy booklet, which clearly stated that the employer would not cover a surrogate pregnancy. Self-insured employers never do. The surrogate conceived triplets, and the insurance administrator advised the surrogate that they would not cover any part of her surrogate pregnancy. Under the circumstances, no replacement coverage could be obtained. She wound up bedridden and in the hospital for the last 2 months of the pregnancy. The hospital bill alone was $250,000. I'm not going to tell you what happened after that. You'll have to read the book or see the movie. For all of these reasons and many more, the contract is an essential part of a surrogacy arrangement. Not only does it cover the law of surrogacy, the rights and responsibilities of the parties to each other, all the financial arrangements, and the necessity of proper insurance, it also plans in advance for the usual and customary problems and contingencies that could arise. For the courts, it confirms separate attorney representation for the parties, preserves the timeline, and instructs the courts on the parties' intentions. In order to wrap yourself in all these protections, you must start by choosing the right agency, one that has the highest integrity, a long track record of success, a favorable reputation among ART doctors, and decades of proud and happy clients. In my view, Building Families, run by Carol Weathers, is the best of the best. All right, let's look now very briefly at a second important document. This is the clearance letter. This is the last step in the contract phase before you move on to the medical protocols. It is a letter I write as attorney for the intended parents to the clinic that will handle all of the ART medical procedures. It assures the doctors that the legal phase is finished, that the contract is fully executed, that the parties were separately represented, that they understand the law and all of their rights and responsibilities, and that they have entered into the contract voluntarily with all appropriate intentions in mind. It also advises the doctors that the intended parents have assumed responsibility for all the ART treatment for their surrogate as well as for themselves. This declaration of responsibility gives doctors permission to seek payment of the surrogate's medical care from the intended parents. Lastly, it lets doctors know that all that could be done has been done to protect the parties, the agencies, the clinic, and the attorneys from any misunderstandings that could blossom into litigation further on down the line. In the early days, doctors routinely requested that they be sent a copy of the executed contract to keep in their files. This was totally inappropriate, as the contract is a proprietary, non-public document. I started sending doctors clearance letters instead of contracts, and I'm happy to report that it is now a universally accepted substitute. That ends video 1. In video 2, we will pick up where we left off.